Thank you very much. Now we'll introduce Mr. Hisney.
Good morning. My name's Tom Hisney. I'm with the Hillsborough County Development Services Department, the zoning section. To my left is Carmen Mason. She also is with the Development Services. Throughout the course of the meeting, we will be joined by a number of planners that will be introduced individually as they present their cases. They will be participating virtually. We are also going to be joined by county attorney staff, which is Cameron Clark and Mary Dorman, during the course of the meeting. I have one change to the agenda, Madam Master. This is on agenda page 10, item H5, Variance Application 22-0349. The applicant is Todd Pressman, and he wishes to appear before you now to request a continuance to the April 25th Land Use Hearing Officer meeting.
All right, thank you, Mr. Pressman.
Good morning. Can you hear me?
We can hear you.
Okay, good. Thank you very much. Again, good morning. Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. We would like to ask for continuance. In reviewing it with Tom, we would have to go to the April meeting to make mailing notice deadlines. We've recently become aware of newer changes and restrictions on splitting lots in regard to infrastructure, and we're still in the process of seeing how this affects what we have proposed, and even if we could proceed at all concerning those recent changes. So with respect, we would request a continuance to the April LUHO meeting, please.
All right, thank you. I'm sorry, that date again is April 25th. Thank you.
Yep.
Thank you. All right, is there anyone here or online who wishes to speak to this application? This is special use alcoholic beverage application 22-0063.
And just clarity of the record, it's for a variance to lot dimensions.
I didn't quite understand that.
It's not regarding. I thought I heard you mention this was alcohol standards. This variance is for lot dimensional standards, or maybe I misunderstood you.
Yes, this is item H5, variance 22-0349.
Oh, I'm sorry. I introduced the wrong one. Okay. I thought you said, okay. My mistake. Variance 22-0349 has requested a continuance to the April 25, 2022 land use hearing. Okay, so is there anyone in the room who wishes to speak, first of all, in support of this application? Anyone in the room or online in support? Okay. To the continuance, and this is only to the continuance request. So if you wish to speak in support of the continuance request. And if there isn't, is there anyone here or online who wishes to speak in opposition to the continuance request of variance 22-0349? So we're not hearing substantive testimony today. This is just to the continuance request. You need to come forward, please, and speak into the microphone and state your name and address, please, first.
Jeffrey Kaplan, 9017 West Flora Street, Tampa 33615.
All right. And yes, sir, you have testimony in regard to the continuance request.
Yeah, I represent about 10. I live right at the corner across the street from the lot, and I'm here representing about 10 of the neighbors. We were given notice, but there was nothing in the notice about what they wanted to do. It's like a big mystery. And we're opposed to any type of continuance. There's really no need. We can have a discussion right now. We're all here.
All right. Anything further, sir?
No.
All right. And I need you, please, to sign in with the clerk's office. Does anyone else wish to speak as to the continuance of variance 22-0349?
Thanks.
Please bring the microphone down so we can hear you. Thank you.
Susan Porter, my address is 9011 West Flora. I took off the day of work to be here and I can't take off another day, so I'd like to continue if we could.
All right. Thank you, ma'am. I need you to sign in with the clerk's office. All right. Would anyone else wish to speak as to the continuance of this item? Come forward and please state your name and address into the microphone.
Yes, good morning. My name is Martha Perez at 6910 East Creek Drive. That's the proposal is one house away from mine's. And I believe we should go ahead and deal with the matter now. I'm going to be doing an international travel at that date, so I won't be able to make it.
All right. Thank you, ma'am. Please sign in with the clerk's office. Anyone else wish to speak to the continuance of this item?
Yes, good morning. I'm Rasa Kaplan. I live at 9017 West Flora Street. I also took off of work today to be here. And, I haven't also a bunch of travel scheduled and, that's just going to interfere with all my work.
Understand. Thank you, ma'am. All right. Is there anyone else who wishes to speak to the continuance of this item? Anyone here or online? All right. Not hearing anyone. Mr. Pressman? Any rebuttal, any comments regarding?
We were complete. Yes, we are complete. Can you hear me? Hearing officer, can you hear me?
All right.
Can you hear me?
I can hear you. The sound's a little muffled.
Okay.
I might ask audio if this speaker over here is on. All right. Would you please restate that, Mr. Pressman? Thank you.
Can you hear me okay, hearing officer?
That's much better, actually.
Okay, good. We have been completely unaware of concern by neighbors. So we would very much like to have the opportunity to sit down and talk with the neighbors. As one gentleman said, I'm representing several neighbors. They were confused or indicated there was little information as to what's being proposed. The notices sent out, of course, are not the most informative thing. So we would very much want to sit down and talk with the neighbors, make sure they understand what the issue is, see if we can make them comfortable with it. But again, because of new changes or changes in regard to infrastructure on these kind of issues, it threw a wrench in the works, and we need to figure out with those new regulations, can we make it work? And if not, we may not be able to and may have to withdraw the application. So there's a lot up in the air, a lot of confusion from the neighbors, and we'd be happy to try and work through those.
All right. Thank you, Mr. Pressman. All right. So variance 22-0349 is requesting a continuance to the April 25, 2022 Land Use Hearing Officer meeting. I will grant the continuance. So this item will be heard on April 25, 2022 at 10 o'clock a.m. As to those who are in attendance today who wish to speak to this item, there is a mechanism, of course, to submit your comments into the record, and those will be of the record, and I will see them. So if you wish to do that, and also, of course, as you heard, the applicant would be happy to have a conversation to talk about the request. So this item is continued to April 25, 2022.
Yeah, and let me advise the people that showed up that I invite you to reach out to me personally if you want to contact me regarding what's being requested and get a good understanding of it. Best way to contact me would, at least initially, would be my email address, which is, I'll spell it out for you. It's my last name and first initial. So that will be HIZNAYT@hillsborocounty.org. And if you don't have a pen and pad, I'll write that down right here for you, and we'll get that handed out to at least one of you. So hold on. Right. Okay, so here. Yeah, go ahead, sir. Thank you. Yep. And yes, I'll be happy to answer any questions. The original case planner that was assigned to this left to get another job. I'm sorry. Oh, Mr. Pressman, his contact information will be in the file. I'll give you instructions how to access what's called the optics file, which is all the records for the case. Also, if you have any questions and, want to ask, like, what's going on, feel free to contact me. And of course, contact Mr. Pressman. His contact information will be in the file. Okay. Okay. And so with that, then I will now read the published withdrawals and continuances. Item A1, variance application 21-0586. The applicant is Irene and Joseph Satana de Jesus and Alejandro de Jerzic. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A2, variance application 21-1248. The applicant is Maria del Rosario Perez and Guillermo del Rio. This application is being continued by staff to the March 21st, 2022 Land Use Hearing Officer meeting. Item A3, variance application 21-1372. The applicant is Alliance Realty Partners, LLC. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A4, variance application 22-0009. The applicant is Annie Mitz Simmons. This application is being continued by staff to the March 21st, 2022 Land Use Hearing Officer meeting. Item A5, special use application 22-0027. The applicant is Mocha Asian Cuisine. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A6, variance application 22-0079. The applicant is John Saldana. This application is being continued by staff to the March 21st, 2022 Land Use Hearing Officer meeting. Item A7, variance application 22-0281. The applicant is Marilyn Machado and Lazaro Duran. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A8, special use application 22-0294. The applicant is the Brandon Bro Food Group Incorporated. This application is being continued by staff to the April 25th, 2022 Land Use Hearing Officer meeting. Item A9, variance application 22-0296. The applicant is Ruba Gassan Real. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A10, variance application 22-0350. The applicant is Go Permit, represented by Jennifer Ronsberger. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting. Item A11, variance application 22-0351. The applicant is David Wright of TSP Companies. This application has been withdrawn by the petitioner. And the final continuance is item A12, special use application 22-0356. The applicant is Aaron Schmalzy. This application is out of order to be heard and is being continued to the March 21st, 2022 Land Use Hearing Officer meeting.
All right, thank you, Mr. Hisney. So before we continue, I'd like to inform you of some meeting procedures today. First of all, the agenda today consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and submit a decision within 15 working days after the conclusion of today's public hearings. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but I will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation today shall be as follows. For variances, Mr. Hisney will call the case. County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. For special uses, Mr. Hisney will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present its findings of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. County staff will then have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal or summation. The 15 minutes for proponents and opponents is the total time allotted among them. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. If there are a number of persons who wish to speak, you may designate a single spokesperson to represent your views. When you come to the microphone to speak, please state your name and address for the record. The meeting is being recorded, so please speak into the microphone so you can be heard and your testimony can be recorded. When you're finished speaking, please see the clerk to my right here to sign in. And now we'll hear from the County Attorney's Office, who will give us the legal requirements and procedures for appeal.
Good morning. This is Mary Dorman from the County Attorney's Office. This Land Use Hearing Officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board. Thank you.
Thank you, Ms. Dorman. All right, all testimony taken today must be under oath. So if you plan to speak, please stand if you're able and raise your hand and I will swear you in. If you're online and you plan to speak, please also raise your hand to be sworn in. All right. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth? All right, thank you. All right, Mr. Hisney, please call the first case.
Okay, we have no vested rights cases today. We have no fee waivers. We have no remand. So this takes us to section E of the agenda, which is reconsideration request. And we have one case. It is item E1, application number variance 21-0914. The applicant is Darren Impson. They're requesting a sign variance. This variance application was originally heard at the August 23rd, 2021 Land Use Hearing Officer meeting. The hearing officer denied the variance on September 13th, 2021. The applicant then sought a reconsideration of the matter as provided by the Land Development Code, and the hearing officer granted the request for a rehearing. On December 13th, 2021, the application was open for rehearing by the land use hearing officer, then continued by the hearing officer to January 24th, 2022 land use hearing officer meeting to allow the applicant an opportunity to correct the record regarding the parcel where the sign will be located. Prior to the January 24th meeting, the application was continued to today's hearing. At this point, I'd like to recognize Cameron Clark at the County Attorney's Office for his comment.
Yes, Madam Hearing Officer, this is Cameron Clark. Can you hear me?
Yes.
Just for the record, because of the nature of this case and the circumstances surrounding it being back before you before reconsideration, this should be handled essentially like a new hearing, a de novo hearing. The applicant should be representing their entire case. The reason being that the wrong property was identified previously, and therefore everything that's in the record would have been off by a little bit, including the staff report and other information would have reflected the wrong property. Therefore, the applicant should represent their entire application, and then staff will present a new staff report.
All right. Thank you, Mr. Clark.
And so I'll introduce Kim King for staff findings.
Good morning, Kim King, Development Services. The applicant is requesting a variance for additional square footage for a pole sign located at 1611 Allison Woods Lane. Per section 703.00C2 A and B of the Land Development Code allows this parcel with 2 street frontages to have either 2 pole signs at 50 square feet per side, 100 square feet total, or 1 pole sign at 100 square feet per side, 200 square feet total. The applicant is requesting an additional 552 square feet of sign area, which would allow a total of 752 square feet for the pole sign. At the January 24th meeting, the applicant withdrew the variance request to increase the height of the pole sign, so they will meet the code for the overall height of the sign. And that concludes my report.
Thank you. All right, we'll hear from the applicant.
Good morning, Hearing Officer Hartley. My name is Fred Mills, and to my left is Paul Elliott, and we were present in December at the time that you had your hearing. The Cameron Clark has made the point and delivered it that we should present in full, but in respect to the hearing officer, I would like to know, do you need a full summary, a full presentation? Or would you like to know how we got here? And I'd like to ask you.
Okay, I understand. I think I know how we got here, but so just present, please, what you're requesting.
Okay.
What your request is.
Okay, so today present is Darren Imson, who is the owner of the land, the fee simple land on which the sign is located. As you pointed out to us, that the sign, even though my client RAF development had an easement, it really was improper if the actual fee simple owner was not present. So, excuse me, not part of the application. So we had amended the application as we discussed at the December hearing. In working, my client, and working both with Kim King and Tom, pointed out that property that's affected needs to be the applicant. So procedurally, we have corrected that. Procedurally, the applicant is DBK Real Estate Holdings with the proper folio number of 067950-0300. Mr. Ibsen is present. He's right here. He will be available if you have any direct questions for him. He has been sworn in those types. In this particular case, since there was the original, which had requests for 2 variances, the height variance is gone. The client has worked directly with the Florida Department of Transportation and eliminated the need. Everything's been cleaned up. It eliminated the need for the height. So they're strictly looking at the size. And so also one of the presentators is George Padilla, which is right here. George will present to you any of the hardships and any of the other questions that you might have. Mr. Ibsen is also present as the fee simple owner. And then RAF Development is the adjacent property owner. So there's 2 acres, his is next to it, and then there's a sign. So the private issue between them is the easement, the sign easement, but Mr. Ibsen is the actual fee simple owner. So any questions for me? And I made a mistake. My name is Fred Mills. My firm is Morrison & Mills, PA. My address is 1200 West Platte Street, Suite 100, Tampa, Florida, 33606. So I'll turn it over. Do you have any questions? Okay, to your name.
Mr. Mills, be sure and sign in with the clerk, please. Thank you.
Good morning. I'm George Padilla. I'm representing RF Land Development and also DBK Real Estate Holdings as far as the design aspects of the project go. A couple of things I wanted to bring into evidence here and submit. If I could use the overhead, kind of show you what we got here. There you go. Just as an overall, what Mr. Mills was stating, the overall parcel's in this darker shaded area. This is the actual parcel that is now the applicant. Okay. And that little yellow spot right there is where the actual sign's going. So just for clarification. So I want to make sure that you have a copy of that. And then this plan you should already have. This is the actual survey of the property. The sign's going right in there, meeting all the setback requirements. That's what's okay. And then what we did was we actually got went and did some research in the area for similar type variances. We were able to pull 5 variances that were granted to kind of prove that what we're asking for is really not uncommon in our area here. You have like the Gator Fort sign right here, Lazy Days along I-4. We're down over here on 75, which is right here. Our location is approximately right there off the interstate. Okay, but you can see down here, you got Outdoor Bass Pro Shop, La Quinta Inn, and I have those variance packages here that I want to submit. It's got the variance numbers and what they're requests for, and they're all within line of what we're asking. I'll get you those. The other thing we wanted to point out was that some of the hardships here, this is on Windhorse Road, which is a dead-end road, and it butts up to 75. So we really have no through traffic in there. So we want to be able to advertise along the interstate for the businesses there. Also, we have, the sign is going to be pretty much the same as everything you see in the area. So those were the main points that I wanted to share with you because I think that, we had talked about it before. And I just wanted to make sure that that was all submitted into the evidence. And I have a little package here that I put together of what I just showed you. I want to submit into there.
Okay, and so you're submitting those to the clerk now?
Yes, ma'am.
And you're just requesting then the variance for the size?
Just
of
the square
sign.
footage of the sign. Yeah, because DOT was able to cut the grass, which looks fantastic. And so now we have some visibility there. So we don't need the height. We just need the square footage because it still kind of sits back quite a ways from the interstate
Okay.
still.
And your target, of course, is to advertise for people driving by on the interstate.
Correct.
Okay,
Yep.
I understand.
Yep.
Anything else you want to add?
I think that's it.
All right. Thank you.
At this point, we kind of presented it. We would like to ask you, again, you've been very patient with us. This is our third time here, so we respect that. We also respect your time. I know we have plenty of time, but is there a specific question you have with regard to ownership or request three? Because we have submitted the deed to show that the 2 acres is owned by DBK. The easements of public record, that's a private matter between, the two owners. We've corrected the deficiencies. We've worked both with Tom and Kim. Believe we've corrected the deficiencies to which you had questions in your original order. And I know it's not totally proper to ask, but are there any questions that you have of us that we could answer?
No, I understand, and I understand the record, and I have reviewed it. I might ask Mr. Empson, since you're here, if you would please just come forward, identify yourself for the record, and state that Mr. Mills is representing your request, and you agree with the request for the variance.
Thank you. My name is Darren Impson. I own DBK Real Estate Holdings, located at 1611 Allison Woods Lane, Tampa, Florida, 33619. And I do agree that Mr. Mills is representing my best interests as well.
Okay. And please sign in with the clerk. I don't have any further questions for you. Did you have anything further, applicant?
No, I do not, but
Okay.
Thank you for your time.
All right. Thank you. All right. Is there anyone here or online who wishes to speak in support of this request? Anyone here or online who wishes to speak in support? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this request? Do not hear anyone. Development Services, do you have anything further?
Nothing further.
All right, thank you. And applicant, any last?
In closing, Fred Mills, in closing, I'd just like to say, I'd like to note for the record that there is no opposition, that we really have worked with county staff and worked our way through. I believe we've covered all the issues. With that, we would respectfully request that it be granted.
All right.
So that's it.
Thank you. Thank you, Mr. Mills. All right, so this will close the hearing then on item 21-0194.
Okay, well, that's the only reconsideration request we had. So that takes us to section F of the agenda, which are site development variances. The first case is item F1, application 22-0184. The applicant is Hindu Temple of Florida. They're requesting a variance to encroach into a wetland setback area and also to fence height requirements. Staff findings will be presented by Carla Shelton.
Good morning. This is Carla Shelton Knight with Development Services. The applicant is requesting a variance from the 30-foot wetland setback conservation area requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on December 22nd, 2021, is to allow for the following encroachments within the 30-foot wetland conservation area setback. Allow the existing paved surface surrounding a sacred banyan tree to remain within the wetland setback area. Allow the existing paver area on the north side of the prayer room to remain within the wetland setback area. Allow a portion of the existing prayer room to remain within the wetland setback area. And place a new fence with masonry columns within the wetland setback area. Additionally, the applicant is requesting a variance to fence regulations, section 6.07.02 of the Land Development Code. Summary of the variances for the wetland setback. For Land Development Code, section 4.01.07.B.4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests an after-the-fact variance for the following existing conditions on the site. A pavement area that surrounds a sacred banyan tree. This area encroaches 21.99 feet into the wetland setback area with 8.01 feet of remaining setback and encompasses approximately 1,800 square feet. B, an area of pavers set in sand, which is located on the north side of the prayer room. This area encroaches 27.88 feet into the wetland setback area with 2.12 feet of remaining setback and encompasses approximately 690 square feet. C, an existing prayer room encroaches 12 feet into the wetland setback area with 18 feet of setback remaining. This area of encroachment encompasses approximately 360 square feet. Item 2, per Land Development Code section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a 30-foot wetland conservation area setback. The applicant requests construction of a new metal fence with masonry columns within the 30-foot wetland conservation area setback. The applicant requests a 30-foot encroachment into the setback to allow for a setback of 0 feet. The other variance for fence height, the subject property is zoned AS1. Per Land Development Code section 6.07.02C2A, fences in agricultural districts are regulated in the same manner as fences in residential districts, except under certain circumstances that do not apply to this case. Per Land Development Code section 6.07.02C1, fences not located in required front yards are limited to a maximum height of 6 feet, except under certain circumstances that do not apply to this case. The applicant requests a 3-foot increase to the permitted fence height to allow a height of 9 feet for a proposed fence to be installed on the north side of the property. Staff findings. The existing prayer room was approved for construction by the county in November 2011 per project ID number 459. The wetland line was located further north in 2011, and the prayer room did not encroach into the wetland setback at the time of the site plan review and permit issuance. Since wetland lines are only valid for 5 years, the wetland line established in 2011 expired and was required to be redelineated and resurveyed. The wetland line shifted southward on the updated survey, resulting in an encroachment of approximately 12 feet into the 30-foot wetland setback at the present time by the prayer room. That's all from staff.
Thank you very much. All right, applicant?
Good morning. For the record, my name is Patricia Ortiz. My address is 2810 North Central Avenue. I'm here today on behalf of Hindu Temple of Florida, seeking variances as described very thoroughly by Carla Shelton. I'd like to let you know that the land is zoned AS1 and it's controlled by Special Use Permit 21-1333, which was approved this past December. This special use permit joins this subject parcel with the parcel to the south and across Lynn Road under one development order, and it formalizes many long anticipated improvements to the temple properties, most notably a 21,500 square foot Vidyala center. The Hindu religion has strong ties to nature. Many religious ceremonies are held outdoors, and the intent of the significant financial investments and renovation project is to create an environment which blurs the boundaries of the built and natural environments as a sort of homage to the temples of Varanasi, India, which is the birthplace of Hinduism. The site does have some unique and unusual characteristics. The area of wetland is located almost entirely off-site, but the property is encumbered by a significant amount of wetland setback. The wetland line has crept south over time, and the wetland acts as a retention pond serving the Jain Temple, the Indian Cultural Center, and Hindu Temple. It appears to be an isolated wetland. Initially, the intent of this variance was to allow reduced wetland setback and increased fence height for a new fence. But while we were in the review process, some existing encroachments were discovered, and they've been included in this variance in an effort to bring the property into full compliance. And I'll show you some pictures.
Okay.
Here you can see the area of pavers set in sand and the prayer room. And to the left of that, you can see the existing chain link fence, which encroaches into the wetland and certainly into the wetland setback. This platform here is the platform surrounding the sacred banyan tree. This platform has been in place since about 2006. The banyan tree is very important to the Hindu religion. It's thought to contain a lot of spiritual energies. It's also believed that the deities and the recently deceased kind of congregate in or around this type of tree. Here's another picture of that platform.
Where is the tree in this picture?
Right here. Right in the center.
Okay, I see the tree in that picture. And so in the next picture, where is that in relation to the whole thing? Where's the
Here's the
tree?
tree right
Oh, I see it behind. Okay, thank you.
Yeah, you're welcome. And you can see there are some permanent structures, some little prayer altars here. Okay, so like as Carla said, the prayer room was approved and permitted through project ID number 459 long ago. And at that time, there was no encroachment, but over time, the wetland has moved. Since,
May I ask, I believe in Development Services report, it was clear that the prayer room, there wasn't an encroachment when it was constructed. But what about the foundation around the banyan tree? Was that an encroachment at the time?
well, yeah, that's kind of interesting. Back in 2011, a site plan was presented for the project 459, and this area around the banyan tree was illustrated on that site plan. But it wasn't discovered that, a variance was needed to address this issue. It just, I believe it was just overlooked, but it is illustrated on that site plan, and I'd like to show you that.
I guess my question is more, whether at that time this structure encroached in the wetland, or has this wetland moved into where the structure is? Not the prayer room, but the structure
banyan.
around the banyan tree.
Yeah, that structure around the banyan tree, this is the 2011 site plan here, and it was within the wetland setback at that time. Mhm.
Okay,
Yeah,
thank you.
no problem. Let's see. And the area of pavers right outside the prayer room, I'm not exactly sure when that was placed on the property. It was after 2006, and it's not shown on the site plan, so after 2011. But, in regard to this, these are semi-pervious pavers, which were assumed to be allowed in the area of wetland setback pursuant to Code Section 40107B, Part 4, which provides for limited exception into the wetland setback. Specifically, or I can quote the code, it says, the limited use of semi-pervious paving material could be allowed. Now, this was not permitted, and the developer will go through the after-the-fact permitting process if you choose to approve it, but there was some uncertainty, based on this section of the code. So in regard to the proposed fence, we're proposing a fence with a maximum height of 9 feet. It will have columns and pillars, which will have a 6-foot height. And then spanning between the columns and pillars will be 4-foot tall pickets. So this fence will not impede the flow of water. It will also have a decorative cap of 2.5 feet, which this is the best picture I have for it, but it will only extend along a certain portion of the property from the northwest corner behind the existing temple, moving eastward towards the prayer room. And here I've tried to outline it in red. So it'll start about here and extend from west to east. In this northwestern corner here, it will be well outside the wetland setback area. But as we move east closer to the prayer room, the setback will decrease to 0 feet at a certain point.
Okay. Where is, I can't really tell from this photo, the fence, does it bifurcate the property, or is it along a roadway, or is that a pond to the north?
Yeah, the fence is located, let me see, I think I have a good picture to show you here.
You did say the wetland, is there a retention pond?
Yeah, okay, so the wetland is actually this retention pond here.
Okay.
Okay.
Thank you.
And the parcel is odd shaped. So this, the fence will extend from about here.
Hold that, if you would please pull the microphone down just a little bit. Thank you.
Yeah. So the fence will extend along this property line between the pond and the temple.
Okay. So most of the wetland area is off-site.
Yes. But most of the wetland setback is on site.
Is on site. Okay.
And that area of 9-foot fence height is only going to be right here along this property boundary. The rest of the property will be fenced in accordance with either the approval of the special use or the code.
The fence, will it be a continuous 9 feet? You said there's columns and then there are shorter pieces of the iron. Is that correct?
Let's see here. So it's a unique fence. It will not be continuous. So we'll have pillars, some columns, then 4-foot pickets. Then for a decorative aspect, we'll have some pillars that are, some columns with pillars on top and then capped. And it's just to provide that sort of artistic look to bring intended to bring like the outdoors in.
I see. And so the columns and the caps, those are the portions of the fence that will be 9 feet.
Correct. There will be some open air area between the pickets and that top cap.
Okay.
And so this will work to do a couple different things. It will define the property boundary for example, it will provide some protection and security, but it'll also keep people from entering into that wetland area. It sort of works kind of like a fence around a swimming pool. Kind of delineate that area of the temple grounds from that area of wetland.
Okay. Could you discuss the hardship with regard to the fence height request, please?
Yeah, well, the fence height is really required to kind of reflect the grandeur of the temple. And we just can't do that with a 6-foot fence height. So what we've done instead is ask for some relief in regard to height with an increase in design to improve the aesthetic. Sort of asking for a balancing act there.
Okay. All right. That's all my questions so far. Did you have?
Yeah, I think that
addition?
really concludes my presentation. I've done a very thorough response to the variance criteria, which we're asking for so many variances here. I think we might just belabor to go through all of those. But, I think the end result will be, in regard to the fencing, a safer situation with more aesthetic appeal. Currently, there is a 6-foot tall chain link fence, which is less compliant than what we're asking for because it does at some point encroach into the area of wetland and it provides zero visual interest. So this will be, a betterment.
Okay.
And, will serve those same purposes of safety and security to the temple grounds.
All right.
And I think that concludes my presentation.
Thank you, Ms. Ortiz.
Thank you.
All right. Is there anyone here or online who wishes to speak to this item as a proponent? Anyone who wishes to speak in support? I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this item? Do not hear anyone. All right, Development Services, anything further?
Yes, this is Carla Shelton. I did want to point out that the site plan that was submitted for this variance shows the banyan tree in question as a 24-inch oak on the plan, but the plan misidentifies that tree. It is the banyan tree.
Thank you very much for that, Ms. Shelton. All right, applicant, anything further?
I would like to thank Carla for pointing that out. That was something that I did mean to mention, but got a little off track there. So,
Ms. Ortiz, did you submit items to the record today, or were those items already there?
I'm going to submit those. I think they're in the record, but I'm going to submit them anyway, along with some additional architectural renderings for you to take a look at.
Okay, thank you very much.
Thank you.
All right, this will close the hearing then on variance 21-0184.
Our next case is item F2, variance application 22-0348. The applicant is Alan Dobbs. It's a request to encroach into the 30-foot wetland setback area. Staff findings will be presented by Carla Shelton.
All right.
Good afternoon. Good morning. This is Carla Shelton with Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on February 9th, 2022, is to allow for construction of a raised patio within the 30-foot wetland conservation area setback. Summary of the Variance per Land Development Code, Section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of an open raised patio within the 30-foot wetland conservation area setback. The applicant requests an 11-foot 4-inch encroachment into the setback to allow for a setback of 18 feet 8 inches. Staff findings. The existing pool and deck on the property were granted a wetland setback encroachment variance number 13-0788 in 2013 to allow an encroachment of 21 feet 10 inches into the 30-foot wetland conservation area setback. This encroachment required a wetland setback compensation planting plan with a planting area of 1,494 square feet, equivalent to the square footage of encroachment into the wetland setback at the time. The current updated wetland line has shifted away from the pool area, and the amount of encroachment by the pool and deck has now been reduced to 1,250 square feet. Since none of the compensation plantings are present at this time, the applicant has proposed a new wetland setback compensation planting plan to include the existing encroachment square footage of the pool and proposed encroachment square footage of the new patio, which is 188 square feet. The proposed wetland setback compensation planting will total 1,438 square feet. A copy of that compensation planting plan is included in the packet.
All right, thank you, Ms. Shelton. Applicant?
Good morning. My name is Alan Dobbs with Florida Design Studio. My address is 5502 North Cherokee Avenue, and I have been sworn. I would like to start with just a few visuals. The first is I just thought it would be helpful to see the orientation of the house and how it's kind of a pie-shaped lot that narrows to the lake. This property owner has an objection on file, which I will address. The area that we are talking about is in this area right here. A little closer view, this shows in the foreground here where this raised patio area is. And the reason it's raised is obviously the site drops down to the lake, but there's quite a few steps here to get inside. So we wanted to kind of reduce that and sort of create like a transition area between the pool and the entry door there. This is on file, but I just wanted to show that the planting plan is part of our what we're proposing, and we do have in the notes here. I don't know, it's on file, but basically we're going to provide an automatic irrigation system, and we're also going to provide monitoring and annual report to Hillsborough County to make sure that this planting area is done correctly and that it's properly maintained, because that was one of the objections by the neighbor next door. This shows the relative minimal impact of what we're encroaching, the red area. The neighbor here is also objecting because he says by doing a raised platform that it's going to create drainage issues, water draining on his property, which is really not the case because everything drains directly to the to the lake. There's very low water flow here, and the little bit that does flow here, there's over 10 feet there for it to not create any impact on his property. And then the red area shows the previous variance for the pool area. And then lastly, in the letter of objection, he addresses a raised deck, but a raised deck is really no different than a deck at grade. So I wanted to show, again, this is a little blow up of the cross section to show that this is the natural grade. And so we're just raising it up to this level right here. We're going to have a little bit of a sitting wall, and then the finished floor is up here. So it kind of creates that transition, and then you can see the natural grade there. This will not obstruct the neighbor's view in any way either. I don't think I need to go through the hardships because those are all on file, but I'll be happy to elaborate on them if necessary.
Yes, it would be helpful if you would, please. You have time.
Okay.
Thank you.
All right. Okay. Well, the first one just relates to the hardships and practical difficulties that are not suffered in common with other properties similarly located. Basically, this additional space requested is a modest addition and encroachment into the wetland setback. This type of space can easily be accommodated in other similar properties, but because of the location of the existing structure and the reasons cited in the previous variance from 2013, it being a pie-shaped lot, among other things, there is no other place on the property for this additional area to be feasibly located. The second one is describe how the literal requirements of the LDC would deprive you of the rights to commonly enjoy by other properties in the same district under the terms of LDC. Many other homes on the lake have large outdoor living spaces and to take advantage of being on the lake. However, this property narrows as it gets closer to the lake, so there's really no way to accommodate any additional space without encroaching on this wetland setback. The third one is that it will not interfere with or injure the rights of others whose property would be affected. I've sort of elaborated on that, but basically it will not adversely affect in any historic surface stormwater drainage patterns. And we'll have a plan to mitigate any surface flow and will enhance natural vegetation and protect the shoreline. The fourth one is how the variance is in harmony with and serves the general intent and purpose of the LDC. The variance would allow the homeowner to enjoy the use of their property in a fashion similar to the majority of the homeowners in the vicinity being on the lake. The fifth one, explain how the situation sought to be relieved by the variance does not result from an illegal act or the result of actions of the applicant. All improvements to this property have been based on legally compliant modification. The proposed patio is a modest addition to something that was previously approved, being the pool. And lastly, explain how the variance will result in substantial justice being done, considering both public benefits intended to be secured by the LDC and the individual hardships that will be suffered by the failure to grant this variance. This variance will allow the current homeowners and all future occupants to have and enjoy outdoor living areas like many other homes in the surrounding area. Failure to grant this variance will diminish the value and usability of outdoor living spaces and not allow the owners the benefits as many of the adjacent neighbors.
Mr. Dobbs, the pool was constructed, I assume, sometime after the 2013 variance was granted. Is that correct?
Yes, it was.
So the pool, sometime around 2013?
Yes, sometime after the variance was approved. When I first started with this project, I didn't think we needed a variance because we made sure that we didn't go out any further towards the lake than the pool. And then when we were in for permitting, we had comments that we needed to do this. So that's why we're here today.
Could you address the purpose of this additional I guess, raised area
Yeah,
or?
well, the raised deck is, so they have the pool with a little bit of seating area around the pool. And they really want to have an area where they can have like a fire pit or something like that. So they have an area for people to sort of congregate, and it's really not feasible to do it on the other side of the property. So this was the most logical place to do it. And we figured, again, since it's such a minimal encroachment, that it probably would be, acceptable. I wanted to address the letters of support and objection. The first one is on file. It's a letter from Aaron Fisher. There was one from another neighbor that apparently is not on file. I checked today, so I'd like to submit that for the record. So I'm not sure.
All right, thank you. You can submit it to the clerk when you finish your presentation. Yes, sir.
And then also there was there's another letter by Vivian Monaco, an attorney. I believe she's going to be speaking. I think I saw that she was signed in online. And then the letter of objection. Oh, that letter was not filed either. But I thought she had sent it. So I have that letter. Let's see. So I'll submit that letter as well. And when she talks, she can probably address that letter in more detail. And then lastly, the letter from the Rush family, which is next door. And they primarily, the 2 points that they raise is the concern for having to raise deck and drainage issues, which I already addressed. And the other was concern for maintaining the plantings, which again, I addressed those as well. So I'd like to, for the remainder of my time, to have Roseanne Clemente, an environmental consultant, to come up and do a presentation. She has a PowerPoint presentation, and then I'll come in and conclude when she's done.
Thank you.
Good morning, Roseanne Clemente, Clemente Environmental Consulting, 620 East Twig Street, Suite 206, Tampa 33602. If you could, I've worked on the Finks property. I helped them restore the shoreline after tremendous erosion due to activity on the lake during the COVID outbreak. There were more people on the lake, and they did a wonderful job choosing a natural way to protect the shoreline. They did not put a retaining wall. Do another one, please. And I added pictures also so you can see the shoreline in front of the pool. Luckily, we have a little blue heron that was there for us. The next picture, please. There's already shrubs right there. There's a well inside that. And then I think there might be another picture. And this is obviously the location of the proposed additional deck. So if you go to the next one. So I've summarized what's the purpose of the 30-foot setback. It originally was enacted to protect the wetland during construction. We had so much trouble with people during construction coming right up to and in the line. It can provide wildlife habitat. It allows for stormwater to sheet flow over the vegetation, which helps reduce pollutant loadings to the lakes. It helps reduce secondary impacts to the wetland, and it protects the wetland during construction. And if you go to my last slide, please. The development on Lake Carroll shoreline has already been reduced for wildlife habitat. The way we've developed on our lake shores, we really haven't left a whole lot of wildlife habitat. But the shoreline continues to be great habitat for shorebirds, which is what we see, ducks and shorebirds. The addition of 188 square feet of patio is not a significant increase in pollutant loading to Lake Carroll. It will still run off and go across the grass and have opportunity for percolation in the soil. And I don't see that the granting of this variance will contribute to any further secondary impacts to Lake Carroll. I think that was it. Thank you.
Thank you, Ms. Clemente. Be sure and sign in with the clerk.
Okay. I'd like to point out in the staff report, the very last sentence says Natural Resources has no objections. And then so in summary, I'd just like to say that, this project will certainly enhance the lake lifestyle while having a minimal impact on the environment. So with that concludes our presentation. Thank you.
Thank you. All right, is there anyone here or online who wishes to speak as a proponent to this item, in support of this item? I believe we have someone online.
Yes, this is Vivian Monaco with the law firm of Watson Sloan in Orlando. Address is 100 South Orange Avenue, Suite 1000, 32801. And I'm here to speak in favor of this variance. I apologize for the late submittal of my letter, but the things just retained me a few days ago. I actually think that that the architect has done quite a good job in going over the variance criteria. There is something that I would like to address, and that is not only the pie shape. Not only is the lot pie shaped, but also in that area, the lake, and you can see that in the aerial from the property appraiser's website that was put up on the overhead. Also in that area, there is a lot in front of or away from the lake next to the applicant's lot that also contributes to the unusual shape. And then you can also see on the aerial that in this particular area, Lake Carroll shoreline actually curves in toward the where the residence is located. And with that, I think everything else for variance criteria has been covered, unless you have any questions for me, Madam Hearing Officer.
I just want to clarify, Ms. Monaco, did you say are you representing the applicant? You're hired by the property owner?
Yes.
Okay, and you're speaking as their attorney, is that correct?
Yes.
Okay, thank you. Thank you very much. Is there anyone else here or online who wishes to speak as a proponent in support of this item? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this item? Okay, don't hear anyone. All right, development services, anything further?
Nothing further.
All right, thank you. And applicant, anything further? No, okay. All right, so this will close the hearing then on variance 22-0348.
That concludes section F of the agenda. It takes us to section G, which are sign variance requests. First item is G1, application 22-0092. Applicants Michael Brooks requesting a sign variance. Staff findings will be presented by Kim King.
Good morning, Kim King, Development Services. The applicant is requesting a variance for an additional sign to be located at the corner of the development that is not considered an entrance to the subdivision. The proposed monument sign is for Ruskin Reserve and will be located on Lot 41 on the southwest corner of 10th Avenue Southeast and 9th Street Southeast. Per Section 70300C3C of the Land Development Code allows 2 entry signs permitted to be installed at each entrance to a platted subdivision and shall not exceed 50 square feet per entrance. The applicant is requesting an additional monument sign at 32 square feet to be located at the corner of the subdivision that is not considered an entrance. That concludes my report.
Thank you, Ms. King. All right, applicant.
Morning, Madam Hearing Officer, Mr. Hisney. For the record, Michael Brooks, Brooks Shepherd and Rocha, 400 North Tampa Street, Suite 1910, Tampa, Florida 33602. Our firm represents the applicant, and I, on behalf, which is Starlight Homes of Florida, the developer of the residential subdivision issue. Betting here, so if I appear as if I can't see at any moment, that's probably true. My glasses are fogging this morning.
Okay.
So you have our application, which I think we've done a fairly thorough job outlining together with what Ms. King has stated. There's a detailed written statement in that package, and so being respectful of redundancy and repetition, but also hitting the high points of what the argument is here. I'd like to quickly walk through that with you. I'm going to show some documents which I believe, except for one, are all on the record, but I do have a package for the clerk that I will leave just to be certain. What you were looking at there is the PD site plan for what the subdivision we call Ruskin Reserve. It is 071885. You can see on that site plan a few things that are relevant to this application. One is that at the time that this PD was approved, and in fact prior to development, 9th Street was just a stub coming off of 10th from the north. And so one of the, you can see on this on the site plan, there were barricades at the end of it. And the condition of redeveloping this project was, rather than coming in through some other entrance, was to complete this piece of the road network, which required a realignment of the roadway as it extended to the south. And it effectively bisects in all respects the Ruskin Reserve subdivision, piece of it on the east, piece of it on the west, with two separate entrances to each of those sides, in addition to the north and the south. So that's this is a copy of the preliminary plan, which reflects that realignment and those connections consistent with the PD conditions.
Mr. Brooks, would you please point out on this map where the sign's going to be?
I'm going to do better than that for you.
Okay. All right, thank you.
So as Ms. King, this is not in the backup, and we made this morning. As Ms. King pointed out, the Land Development Code allows 2 monument signs at each entrance. It doesn't define entrance within the LDC specifically, and we're not here to challenge that today. What our point is that effectively, because of the way that the regulatory approvals for this project were structured, and the fact that the north-south roadways was extended really through the development, that the functional entrance to this subdivision is off the main is off 9th Street. And so what this exhibit demonstrates is that, because I can't see that one over there, I'm going to use my cheat sheet, is the stars are the locations in which monument signs would be permitted under that interpretation of the Land Development Code requirement. And you can see there are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 locations. What the applicant is proposing is that on 14th Street, where you see that yellow star, is that would be the entrance that would identify the subdivision for the residents on that portion of the project and for the traveling public on 14th, and that the circle represents the monument sign that is the subject of this variance. And so rather than having it down at one of these local road entrances, have it still within the subdivision, but at that corner of 10th and 9th.
Okay, and clarify for me, please, Mr. Brooks, red stars, what do they indicate again?
Those are permitted sign locations with no proposed monument signs.
Okay.
I think that's important. The yellow star is permitted monument sign locations where there is a proposed sign, meaning of all the permitted locations, we're proposing to utilize one of those. And the circle is in lieu of all of these internal signs that we put one sign on 10th Avenue, 10th Avenue at 9th Street, similar to the sign that would be at 9th and 14th. And again, as we outline in our variance request, for all intents and purposes, 9th Street really does act as the entryway and the primary access to this subdivision. Again, we're not challenging that interpretation. We have identified each of the variance criteria. Would you like us to walk through each of those?
If you don't mind,
Yeah,
briefly,
sure.
please. Thank you.
Sure. I don't want to be repetitive here, right? As to number one, which is unique and singular, the variance involves a platted residential subdivision, so we fit that piece of the code. It is an L-shaped tract of land that is partially bisected by 9th Street Southeast, and for all intents and purposes, it functions as a primary entrance into and through Ruskin Reserve from both 10th at North Terminus and 9th Street, 9th Street at the southern terminus. The entryway function is not diminished in any meaningful manner by the fact that Ruskin Reserve subdivision comprises only the western side of the right-of-way on the north end. It is still the primary user of that road right-of-way, with the exception of a small, low-scale apartment project located on the northeast corner that I understand is used for agricultural workers. Second one is private of the right. So strict interpretation of the code here would deprive the developer, together with the future owners of the subdivision and the traveling public who rely on these monument signs, such a monument sign at the functional entrance, which is a right that's commonly enjoyed by all subdivisions that are more uniform in their shape and access configuration. Number three, explain how the variance would not substantially interfere. As I said, it would neither impact nor injure the rights of surrounding property owners. The monument sign would be located within the residential subdivision, Ruskin Reserve, and so that there should be no confusion to anyone in that regard. I will mention at this point, with regard to this point, that we did notice this project 3 times. And so through that process, we've not received a single phone call and no one has raised any concerns with what we're asking for. With regard to the general intent, again, we think that this request is in harmony with the general intent of the Land Development Code that allows entry monument signs into the placement of those at subdivision entrances. This is not a result of an illegal act of the developer. In fact, it was a requirement of the regulatory approvals that dictated the design of the subdivision and the entry function of that roadway as its access. And then with regard to the last criteria, the substantial justice, benefits weighing versus hardships, we're not aware of any hardships. And the benefits, again, are related to the fact that we believe that's the functional entrance of the subdivision. So with that, I'll answer any questions you have.
I don't have any more questions for you. Thank you.
Okay.
Be sure and sign in with the clerk's office.
In the, I do want to state one last thing for the record. Ms. King had mentioned this as a request for an additional sign. That's obviously not, maybe in one sense that it could be viewed that way. What we're really looking here, as you can see on this exhibit, is rather than having 10 signs throughout the community along Ninth is just to have two. And I know that we don't have sign plans anymore, but I wanted to make it clear that we are not putting all those signs in. Lastly, there are no other variances related to the size of the sign, to the setbacks of the sign, to the lettering on the sign. So it is only the location that we're here for today. Thank you.
Thank you. All right, is there anyone here or online who wishes to speak in support of this variance? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request? Don't hear anyone. All right, Development Services, anything further?
Nothing further.
All right, thank you. Applicant, did you have anything further? No, okay, thank you. This will close then the hearing on variance 22-0092.
Our next case is item G2, variance application 22-0132. The applicant is Mark Brenchley. The request is for a sign variance. Staff findings will be presented by Kim King.
On this variance, the applicant is requesting a setback variance and variance for additional square footage to replace an existing monument sign with a new pole sign located at 14703 North Del Mabry Highway for the Marketplace North 2 Shopping Center. Per section 7.03.00 C2 A and B of the Land Development Code allows this parcel to have either two pole signs at 50 square feet per side, 100 square feet total, or one pole sign at 100 square feet per side, 200 square feet total. Per section 703.00 C1B allows a pole sign to have a 10-foot setback from the right-of-way line. The first variance, the applicant is requesting an additional 168 square feet of sign area for a proposed pole sign, which would allow them a total of 368 square feet of sign area. For the second variance, the applicant is requesting a 5-foot variance from the right-of-way line, placing the sign at a 5-foot setback. And that concludes my report.
Thank you, Ms. King. Applicant?
Good morning. My name is Mark Brenchley. My address is 3790 Beacon Ridge Way, Claremont, Florida, 34711. I represent the owner of this shopping center, and that is ORL-PX LLC. They are the owner of the shopping center, the northern, it's called the Marketplace North 2 Shopping Center, owned and managed by the Wasatch Enterprises and so forth. As Kim mentioned, this is a replacement of a existing monument sign to install a pylon sign. Thank you. This shows the two different signs. The existing one that is over 30 feet tall, and the new one, which is 27 feet 4 inches tall. The existing monument sign has over 250 square feet per face, so about 500 square feet of total sign area covering both sides. And as Kim mentioned, this proposed sign is now a pylon sign. And pylon sign is described as having 8-foot clearance from grade to the bottom of the sign, which allows for the visibility triangle looking up and down the street. As you can see, this existing one, which has a current 5-foot setback, was installed 40 years ago when the shopping center was first developed. I'm certain that Dale Mabry probably has been widened since then to reduce that setback now to a non-conforming 5-foot setback. And this shows a better graphic example of the location at the base of the sign. The developer wishes to install the new sign using the foundation system that is there, and so they wish to retain that 5-foot setback. Now, one of the hardships that I wish to mention is showing them the full site plan. Dale Mabry here on the left of the property. The current sign location here is located in an island, a parking lot island. If we were required to move the sign to a 10-foot setback, it would alter negatively that north-south driveway access that provides access to much of the entire shopping center, as well as the parking stalls that are abutting Dale Mabry. Also, another hardship that I wish to illustrate here on this photograph. Again, by moving the setback or the sign's 5-foot setback will decrease the visibility of the sign from approaching Dale Mabry traffic. The speed there is 40 miles an hour. And by the time, if the sign is set back further behind this tree on this perspective, it would be difficult for them to identify, because the sign is now changing dramatically. And so there is some historical wayfinding opportunities that would be lost if we had to move it back further into the parking lot, again, encroaching upon that very valuable north-south driveway access.
Mr. Branchley, does that photograph there, is the existing sign in there somewhere?
Yes, right here.
Okay, thank you. Thank you.
Yeah, I labeled it sign. And this,
I see.
all these documents were submitted
Okay.
For the application. So I discussed in the difficulties, a hardship by moving it back, both physical as well as visual challenges will occur. Item number 2, describe the literal requirements of the Land Development Code will deprive you of rights enjoyed by other properties in the same district. Well, this very large sign has existed there now for 40 years. And so if they were to required to retain, or at least to comply to the ordinance, it would be a substantial reduction in visibility and sign area, thank you, for the shopping center. All these properties up and down Dale Mabry have similar size signs because they were installed 30, 40 years ago in this section of Dale Mabry's development. The item number 3, it will not substantially interfere with or injure the rights of other property owners. As I mentioned, it is a reduction in both size and I think gaudiness as well. So it's existed there for 40 years at that same location, and it has not interfered with or deterred any type of development. How does it serve the general intent and purpose of the LDC? I think this is especially where it is important to note. It promotes the intent outlined in section 1.02, 0.03, and fosters the consistencies of established regulations, respects the rights of property owners and of adjacent property owners, and considers the interests of the citizens of Hillsborough County by improving the aesthetics of signage while reducing signage nonconformities, but especially maintaining orderly and harmonious development of the unincorporated areas of Hillsborough County. So clearly, this is a significant reduction of the nonconformity, which is always the goal of all sign codes to bring them into a consistency. This does not result from a illegal action. The nonconforming setback probably has occurred through, as I mentioned, over the 40 years of the widening efforts of Dale Mabry. And then lastly, number 6, the allowing the variance will result in substantial justice being done. And the individual hardships that will be suffered by a failure to grant a variance, the public is benefited by a re-imaged and enhanced sign that is more aesthetic, that is designed to better facilitate visibility for motorists and visitors to the site, that is more conforming not only to the code, but to current architectural trends and styles. Therefore, approving the variance will result in substantial justice being done, considering the public and the intent of the LDC, and especially considering the individual hardships that would be suffered by a failure to grant the variance. That's the presentation. Thank you.
Thank you, Mr. Branchley. All right, is there anyone here or online who wishes to speak as a proponent in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? Don't hear anyone. All right, Development Services, anything further?
No, nothing further.
Thank you. Mr. Branchley, anything further for the applicant? No. Okay, thank you. So this will conclude then the hearing on variance 22-0132.
And that concludes section G of the agenda. It takes us to section H, which are the general variance requests. First case is item H1, application 22-0108. The applicant is Daniel Zimmerman. They're requesting a variance to accessory structure requirements and the lot development standards. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. The applicant is requesting a variance for a proposed detached garage on a single-family lot, zone ASC1. For the Land Development Land Development Code, section 61104C1 and section 60101, the required setback for the proposed garage is 50 feet. The applicant requests a 5-foot reduction to the required setback to allow a front setback of 45 feet from the west property line for a proposed detached garage with a height of 19 feet. Also, per the Land Development Code, section 61104B, accessory structure shall not exceed 15 feet in height, except where the structure meets the primary structure setback of the property zoning district, in which case the maximum building height of the district applies to the accessory structure. Per the Land Development Code, section 60101, the required minimum front yard setback for property zone ASC1 is 50 feet, and the maximum permitted building height is 50 feet. The applicant requests a 4-foot increase in the maximum height permitted for an accessory structure that does meet the required front yard setback to allow a height of 19 feet. The applicant obtained approval last year for a setback variance 210566, for the proposed garage, which at the time was designed with a maximum height of 15 feet. The applicant now wishes to increase the design height of the proposed garage and is required to seek approval of a new variance. This concludes my presentation.
Thank you, Ms. Chapella.
Yeah, Madam Hearing Officer, there's a typo I just want to point out in the variances in paragraph 2, the last sentence. Applicant requests a 4-foot increase to the maximum height permitted for an accessory structure that does not meet the required front yard setback.
Thank you.
Yep.
I see that. Thank you, Mr. Hisney. All right, is the applicant here?
Yes. Thomas Ferrier, Madam Chair, with McFarland, Ferguson, and McMullen. I also have with me here Mr. Zimmerman, who is the owner of the property.
Thank you, Mr. Ferrier. Go ahead.
As was mentioned earlier, Mr. Zimmerman applied for a variance to encroach on his front setback 5 feet. That was heard last March by you all, and it was granted. At the time that that variance was granted, Mr. Zimmerman and the parties agreed to a 15-foot height restriction on the height of the garage. At the time, they thought this would be sufficient. After obtaining that variance, Mr. Zimmerman went forward with the design process for the garage. It was not originally believed that there would need to be a pitched roof on the garage, but after entering the design process, it was determined that a pitched roof would be needed. And it was then, he then learned that he would need 19 feet of height in order to fit the requested garage in there. Accordingly, we're seeking this 4-foot increase so that Mr. Zimmerman can use the garage for his intended purpose in obtaining the original setback and use it to house his boat on his property, given the unique shape and nature of his property, kind of sandwiched between a wetland and 54th Street.
So just to be clear, the prior variance, did that approve the setback, the 5-foot setback that is also included in this request today?
Yes, ma'am.
So that was approved, and now Mr. Zimmerman is seeking additional height.
Just the height, correct. Today we are seeking the height increase of 4 feet, from 15 feet to 19 feet.
Okay, I understand.
Madam Master. Yeah, since the first variance that was approved, the fact set for that was there was a 15-foot height. And so he's required to ask for a new variance, but this variance is for both the setback and the height because of, they're kind of linked. So I just want to make it clear the variance today is both setback and height.
Thank you, Mr. Hisnate. I understand that now. Thank you. All right, Mr. Ferrier, did you want to address the hardship issues?
The hardship issue being, Mr. Zimmerman obtained the variance originally to build this garage. As I mentioned earlier, his property is unique in that it's a kind of a triangular shaped piece of property located between Delaney Creek and a wetland on one side and 54th Street on the other. He sought the variance to build this garage for his boat, and the only place he could locate it, given the wetland, was into the setback. And so the hardship being without obtaining this height variance, it would deprive Mr. Zimmerman of the intended use of obtaining the 5-foot, the variance originally in building this garage.
All right, thank you, Mr. Ferrier. Anything further?
Nothing further.
All right. All right, then, is there anyone here or online who wishes to speak in support of this variance request? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request? Do not hear anyone. Development Services, anything further?
No, ma'am.
Thank you. Applicant, anything additional?
No, the only, I guess what had happened was when we originally,
Sir, would you please state your name and address for the record? Thank you.
Yeah, Daniel Zimmerman, 3308 South 54th Street, Tampa, Florida, 33619.
Thank you. Go ahead.
Yeah, when we originally did this and the design build people that we talked to about the building, no one had ever said we need that additional height in order to put the garage door in, the rolling garage door. And so we went ahead and went with the first variance, thinking that we would be able to fit the garage door in at that height. After we got the first variance and went to move forward with the design and build company, they came back and told us that, we needed that additional height in order to put the rolling garage door in there.
All right, I understand. Thank you. Anything further?
No, that's it.
All right. All right, that will close then the hearing on variance 22-0108.
Our next case is item H2, variance application 22-0161. Applicant is Michael Kretzinger, requesting a variance to lot development standards. Staff findings will be presented by Tim Lampkin.
Good morning, Tim Lampkin, Development Services. The applicant is requesting setback variances to accommodate a proposed single-family home on a property that's zoned PD 91-0148. For condition 3 of PD 91-0148, the minimum required setbacks for the subject lot are as follows: 25 feet for the front yard, 7.5 feet for the side yard, and 25 feet for the rear yard. The applicant is requesting 1, a 2.5 foot reduction to the required side yard to allow a setback of 5 feet from the east property line, and 2, a 2.5 foot reduction to the required side yard to allow a setback of 5 feet from the west property line. And that concludes staff's presentation.
Thank you. Applicant? Is the applicant here for variance 22-0161? All right, not online and doesn't appear to be present in the room. All right. Should we try to call the applicant? All right. Shall we? Okay. All right. Shall we come back to this one then? Okay. All right. So variance 22-0161, we're going to close the hearing for now. We'll reopen in a few minutes when the applicant connects. We'll move on to the next case.
Our next case is item H3, variance application 22-0239. The applicant is Alvaro Rodriguez, requesting a variance to lot development standards and accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. The applicant is requesting two variances to accommodate an existing room addition and a detached shed for a single-family home on property zone PD 730197, as most recently modified by PRS 20-0332. The first variance is for a room addition. The conditions of approval for PD 730197 do not address setback requirements for the subject lot. In such cases, development standards are determined by the zoning administrator per the certified site plan, approved plat, or other means. It has been determined the required minimum side yard setback for the subject lot is 7.5 feet. The applicant requests a 4-foot reduction to the required side setback to allow a setback of 3.5 feet from the east property line. The second variance is for a detached shed. For the Land Development Code, Section 61104, accessory structures 15 feet or less in height may occupy required side yards, provided that such structures are not closer than 3 feet to any rear lot line. In the subject case, the shed is closer to the street than a portion of the house. Therefore, the shed is required to meet principal building setbacks. The required side yard setback is 7.5 feet. The applicant requests a 5.37-foot reduction to the required side setback to allow a setback of 2.13 feet from the east property line. The applicant states the shed is less than 15 feet height. This concludes my presentation. There are findings and more information on the report, but this concludes my presentation.
Thank you, Ms. Chapella. The applicant, please.
My name is Álvaro Rodriguez. My address is 3603 West Florida Street, Tampa, Florida, 33614. As Ms. Tanya explained, this is the addition that the owner did in this house. The addition is like a stair addition, and some of the corners of the addition get encroached on the setback. This is the closest one that is encroached 4 feet into the setback, and we are asking for a variance for a 3.52 on this corner. The accessory structure that is a shed is only 0.87 feet inside the setback. We are asking just for, this is supposed to be 3 feet, and we are asking for 2.13 setback on that area. The other variance is on this side of the house. This house is the original house. This was done a long time ago when they built the house, but it's encroached on the setback. And the encroachment is for 1.17 feet. That means that the setback will be 6.33.
Okay, Mr. Rodriguez, how long have you owned this property?
The owner owned the property for three years. 6 years.
Okay, so you're not the owner then?
No, I am the agent.
Okay, so the owner has owned this property for 6 years?
Yes.
Did this owner build this addition to the house?
Yes, she did it.
When?
3 years ago.
3 years ago?
Yes.
Was it permitted?
No.
It was not permitted?
No.
Okay.
The addition on the right was not permitted.
I'm sorry, what?
This addition was not permitted.
Okay. Thank you. And did this owner also construct the detached shed?
She installed the detached shed was already there? No, she didn't.
No.
She did the detached shed.
So the existing owner, the current owner also built the detached shed.
Yes.
Okay, the online person, just stand by, please. Mr. Rodriguez, was the detached shed permitted?
No.
Okay, thank you. All right, please proceed.
Okay, this is the existing house. And the addition that she did is just a little laundry area and a covered lanai and one space for her mom. There is a really hardship on this condition, and I would like to be really specific with you about this. Dianelli and her sister, they have to take care of her mom. Her mom has Alzheimer's, and she has to be supervised every time. I mean, 24 hours. She cannot even recognize herself on the mirror, and she cannot eat by herself. She cannot go to the bathroom by herself. And her sister and Dianelli, they have to be 24 hours with her. They create this little addition on the garage was already there, but they convert the garage on a bedroom, and they add a little space to have her mom to eat. But there is no cooking space. There is nothing to cook on that space. I already explained that. Everything that is cooked for her mom is on the kitchen. This is a special. I think that is a hardship for them. Her mom has to be all the time supervised. Dianelli, her mom, and her sister are here. We also have the neighbors for the properties that they will be talking about this. And this concludes my presentation. I would like to invite Alice to come here. Any question?
Are you going to address the hardships as regards the property? Or did you say someone else was going to speak?
Dianellis and her mom, they are here.
Okay.
They're going to speak.
All right, thank you.
Dianelli does not speak English. She has somebody to translate for her.
All right, thank you. Please, Mr. Rodriguez, sign in with the clerk's office. And you can pull the microphone down, so thank you.
Mi nombre es Dianelli Castro Ávila y la dirección es 16135 Ravendale Drive, Tampa, Florida 33618.
Gracias.
Her name is Dianellis Castro, and her address is 16135 Ravendale Drive, Tampa, Florida. Oh, I'm sorry. And my name is Angela Rodriguez. My address is 6014 Pratt Street, Tampa, Florida 33647.
And did
Yes.
proceed, please?
Ok. Bueno, yo les quería, primero antes que todo, buenos días todavía. Estoy un poco nerviosa. Debido al estado de salud de mi mamá, me vi obligada a hacer una modificación de la casa para que mi hermana y yo pudiéramos supervisar a mi mamá. Creamos un espacio habitable en el garaje y una pequeña adicción al costado de la casa. La condición de salud de mi mamá ha sido increíblemente difícil para toda nuestra familia, porque su condición de Alzheimer ha empeorado tanto al punto que nunca puedo dejarla de supervisar. Mi hermana y yo nos turnamos para trabajar, comer e incluso hasta para dormir. La situación se ha vuelto tan crónica que mi mamá no se reconoce hasta en el espejo. Es incapaz de realizar cualquier tarea de la vida normal. Se apunta, traigo los récords médicos de mi mamá, si los necesitan. Espero que puedan comprender la gravedad de la situación. y la necesidad de que tanto mi hermana como el resto de mi familia pueda cuidar y vigilar siempre de mi mamá y de su salud. Nunca pretendo pasar por alto las regulaciones del condado. Solo estaba tratando de hacer una adicción razonable para mi mamá.
Due to the health condition of Miss Daniele's mom, Daniele was forced to make an accommodation in their home, so she and her sister must always be able to supervise their mother. They created a living space in the garage and a small addition on the side of the house. Miss Avila's health condition has been incredibly difficult for the entire family because her Alzheimer's condition has worsened that they cannot even leave her without any supervision. They need to make turns to work, eat, and sometimes to sleep. Her condition has developed to be so chronic that her mom doesn't recognize herself in the mirror, forget where the bathroom is, and she's incapable of performing any regular task. We hope you understand the gravity and the situation and the need for both sister and the rest of the family to always take care and oversee Miss Avila's and her health. Ms. Danielis never pretended to go over any county regulations. She only was trying to make a reasonable addition for her mom. And they also have the medical records here if for any reason you need it.
I don't need those. Thank you, though. All right, anything further? All right, thank you. Please, both of you sign in with the clerk's office. And Mr. Rodriguez, did you have something further? Well, would you come forward, please? Just a question for you. And please raise the microphone back up. Thank you. The hardship criteria really have more to do with the property itself. And I understand the situation that was explained. Is there anything further you can say about the property itself related strictly to the hardship criteria?
That was the easy way that they can create that space for her mom. That was the cheapest way to do it. They cannot have any kind of expansion on the back of the property because there is an easement on the back that is a drainage easement. And they are, because sometimes we try to get to another place to put it on, but that would be the easy way to do it, the fastest way to do it. And without that easement on the back, they couldn't move to the back more. Other than that, I think that this is more, they apologize for all the problem that they have with the county, but that was the best way that they found to do that addition really fast. Other than that,
All right. Thank you, sir. All right, is there anyone here or online who wishes to speak in support of this variance? Please come forward.
Hi there, my name is Spider Zero Prime. I represent myself and my wife Megan Prime, and we both live at 16133 Ravendale Drive, Tampa, Florida 33618. We are the neighbors directly adjacent to their property. We have no issues with the proximity of their dwellings in relation to ours.
All right, thank you very much. Please sign in with the clerk right here. Thank you. Is there anyone else here or online who wishes to speak in support of this variance application? All right, don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance application? Do not hear anyone. All right, Development Services, anything further?
Yes, I just want to advise the applicant and have them confirm on the record here that if these variances are approved, they will be required to obtain after the fact building permits for the addition and the shed. And if the applicant's rep can confirm his understanding of that on the record, please.
yes, I know exactly what we're supposed to do.
Thank you, Mr. Hisney. Mr. Rodriguez, does the addition and or the detached shed, do they have electrical, do they have electricity and plumbing and so forth?
The shed has a couple of pipes, but I already advised the owner that she has to remove that. She cannot have any kind of plumbing on that shed.
It has a couple of what?
Pipes.
Oh,
It does, yes, it doesn't have any bathroom or anything running water, no. But has a couple of pipes. They were thinking maybe to put something there like a bathroom. I told them no. The only way that they can use that shed will be for storage. She's already advised about it.
All right, and the addition to the house, then I assume it has electricity?
Yes, of course.
Okay. All right, did you have anything further to add?
No.
Okay, thank you, sir. All right, so this will close the hearing on variance 22-0. Let's see, what was that one? Is that correct? 22-0239 is closed.
So, Madam Master, the applicant for the previous case, 22-0161, is now connected here and can participate in that hearing.
Okay, thank you, Mr. Hisney. We'll reopen then variance 22-0161. We've heard from Development Services. Applicant, please.
You're fucking waiting for the day to pass?
Sorry, Mr. Kretzinger? Mr. Kretzinger, is he online?
Yeah. Michael, can you hear us? Michael, you're unmuted right now. Can you hear us?
Hello?
Yes, can you hear us, sir? Michael, can you hear us?
Hello?
All right, we can hear you, Mr. Kretzinger. Can you hear us? And we also need to be able to see you. Do you have a video?
Hello, this is Mike.
All right, Mr. Kretzinger, we can hear you. Can you hear us?
Someone's going to have to call Michael and let him know that he cannot hear us.
Okay.
There's no way that we can get in touch with,
Okay. All right. Well, we're going to move on then. We're going to reclose variance 22-0161. And we need to try to reconnect with that applicant. So let's move to the next application.
All right, our next case is item H4, variance application 22-0258. The applicant is Laura Beth Kendrick, requesting a variance to lot development standards and accessory dwelling requirements. Staff findings will be presented by Chris Grangillard.
All right. All right, Development Services, Mr. Grand Leonard, are you on the phone or online?
He told me he had jury duty today.
Okay, stand by, please.
Chris has duty today, Tom. This is Israel Monsanto.
All right, thank you, Mr. Monsanto. Will you be presenting for Development Services? This is variance 22-0258.
I believe Mr. Hisney is. He should be confirming.
Okay, one moment. Thank you so much.
About that. So All right, I'll present the findings then for 22-258.
Thank you.
All right, so the applicant is requesting variances to accommodate a proposed addition to an existing family home that will include an accessory dwelling on property zoned RSC3. Land Development Code, so we have a primary dwelling, and what's going on here is we have an existing primary dwelling and we have a detached garage. The applicant wishes to connect the detached garage to the home so that everything will be connected. Additionally, on that new addition, they want to include an accessory dwelling on the second floor. So for the primary dwelling, which will now include everything, because it's all going to be connected, the code requires a side yard setback of 7.5 feet in the RC district. Applicant requests a 3-foot reduction to, it's a side yard setback of 7.5 feet. And excuse for the typos in the report. Anyway, so it's a 7.5 foot side yard setback. The applicant requests a 3-foot reduction to the required side yard to allow a setback of 4.5 feet from the west property line for the addition and the existing garage and everything else. Now, as far as the accessory dwelling that's proposed on the second floor, accessory dwellings are required to meet principal building setbacks. As previously stated, the RC3 district requires a 7.5 foot setback. They're requesting a side yard setback, requesting a 3-foot reduction to allow a setback of 4.5 feet from the west property line. The applicant has been advised that the accessory dwelling must have a bathroom and kitchen and cannot exceed 900 square feet of living space. Also, this lot is served by a septic system, and under the code, currently has the requirement is a 1/2 acre of upland area. This parcel has approximately 1/3 of an acre of upland area, and therefore is non-conforming. However, it has been certified as a legal non-conforming lot per NCL 22-0404 in the case record.
Thank you, Mr. Hisney. All right, we'll hear from the applicant.
Hello, my name is Laura Kendrick, and I live at 11306 Sylvan Green Lane, Riverview, Florida, 33569. I'm applying for a 2-car garage with an accessory dwelling unit above it. I currently have a single-car garage, and there's no other place to build except in front of it. I don't live in a deed restricted neighborhood, so there's a very mixed bag of houses on my street. Some are single car, some are double car garage or multiple car garages. And I have some neighbors that have signed a petition in support of my my variance on either side of me and in front of my house.
All right, thank you. I'm just looking at your survey, and I just wanted to make sure I understand it. So your structure is existing. You have a detached garage that's existing, and it is sort of behind your residence, or it's set back behind your residence. Okay, and then you're seeking to create an addition to your residence that will also connect with the garage. Is that correct?
Correct.
And on the floor, the bottom floor, there will be garage space?
2-car garage, yes.
Okay. And then on top of the garage space, you're going to have a dwelling unit.
Correct.
Correct. And how many square feet is that dwelling unit? Will that
approximately 600.
Okay. All right. And you're aware that it has to have bathroom and kitchen?
Yes, ma'am.
Okay. Would you please speak to the hardship criteria that are applicable for a variance?
Well, I don't have any space for a two-car garage on my property.
Mhm.
I don't have the sheet in front of me. to be
Okay,
honest with you.
I do have the written.
Okay.
Okay, anything that you want to add to that?
Well, I plan to rent it out to travel nurses. I'm a retired nurse myself, and they're going to be building a hospital right around the corner from me, Advent Health on 301, and they're going to be employing 2,000 people, and there will be a need for housing for these employees. So that was my intent.
Okay, anything additional you want to add?
No.
All right, thank you very much. Be sure and sign in with the clerk's office here. All right, is there anyone here or online who wishes to speak in support of this variance? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance? All right, I don't hear anyone. Development Services, anything further?
No, ma'am.
All right, thank you. Ms. Kendrick, did you want to say anything else, or you had something you want to submit to the record? Come to the microphone, please.
I wanted to submit the petition in support of my variance.
Okay, thank you very much. Leave that with the clerk. All right. If nothing further from the applicant, that will close the hearing on variance 22-0258. It's a little after 12. Should we take a 5-minute?
Yes, ma'am.
I think we should take just a 5-minute quick comfort break. We'll be right back. while we're waiting on the former case to connect.
Okay.
Mr. Hisney?
We have one last case other than the variance that we're trying to get the audio connection. And this is a special use. It's item H1 on the agenda. I'm sorry, that's incorrect. It's not H1. It is a special use and it is, sorry, here we go. It's item J1 on the agenda. It's a special use application 22-0063. The applicant is SRJ Restaurants Incorporated. The request is for a 4 COP RX alcoholic beverage permit, which requires a separation waivers. Israel Monsanto will present the staff report and recommendation following the applicant's presentation.
All right, applicant?
My name is Sherry Allday. My address is 22638 Eagles Watch Drive in Land O'Lakes. The property is at 5229 Ehrlich Road in Tampa. And it is the inside building is currently already zoned for COP RX for the restaurant. We want to increase the footprint of that to include the outdoor patio area so that the customers who want to sit outside can get the same service that they get inside. And it is within the 500 foot of the Ben Hill Middle School, and 2 churches are located close to us also. There shouldn't be, many of our customers want to sit outside due to the COVID stuff now. They want to be outside instead of inside. So those 3 properties, the first one is the middle school, which is within 500 feet. To their property line, to the actual school building is outside of the 500 feet. And all we're proposing is just an additional 5 foot closer to the school to include the outdoor seating. And then the churches, there's one behind the restaurant or the building complex, which is separated by the actual L-shaped building plus a 6 foot privacy fence. And then the church property is behind that. Then there's a church property across Hutchinson, which is also within the 500 feet. And as far as I know, the only objection was a standard letter from the school board. So, and that's pretty much it.
Okay. So as far as the school, and I understand the actual school building you said is outside the
It's outside
500.
the 500 feet.
And what about the churches?
The churches, they are the one across Hutchinson, the Lutheran church is, the property line is within, their church building is not, it's set further back. The north, I believe it's called Northwest Community Church. The building actually is, but as I said, it's separated by the back of the complex. We're all the way in the front of it, and it's separated by that whole thing plus a 6 foot fence.
Okay. All right. Anything further you want to add?
No, I don't believe so.
Okay. Thank you. Be sure and sign in with the clerk.
Okay.
All right. Development Services.
Good afternoon. Israel Monsanto Development Services. The applicant seeks approval for a 4-cup RX alcoholic beverage permit for a restaurant which is located at 5229 Elric Road. The requested wet zoning allows the sale and consumption of beer, wine, and liquor on the permitted premises only in connection with a restaurant. The site currently has an approved 4-cup SRX wet zoning under permit AB 851216 for the sale and consumption of beer, wine, and liquor on the permitted premises only in connection with a restaurant. The current approved wet zone area is 4,270 square feet of enclosed space, and the site is located in a shopping center. The property is on commercial neighborhood, which permits restaurants and consideration of the proposed wet zoning. As the applicant has stated, the subject wet zoning seeks to expand the current special use AB permit wet zone area to allow outdoor patio areas, 1,414.1 square feet along the west and south of the existing enclosed premises. And this is indicated in the survey submitted on February 3rd, 2022. If the requested wet zoning is approved, the existing wet zoning will be rescinded. As the applicant also stated, there are three community uses within 500 feet. Therefore, the site doesn't meet the distance requirements per the Land Development Code. Therefore, waivers are being requested. The applicant has provided justifications. In summary, for the church to the north, which is Northwest Community Church, although the church is within 500 feet in a straight line, it is located behind a shopping center and is also separated by a 6-foot high fence. The shopping center is L-shaped, and the proposed wet zone space is located on the furthest end of the shopping center. In regards to the Messiah Lutheran Church to the west of the site of the proposed wet zone area, this church is located on the other side of Hutchinson Road. The parking lot of the church is within the 500 feet distance from the proposed wet zone space, but the church building itself is outside. It's more than 500 feet away, as also indicated in the staff report diagrams. And in regards to the Ben Hill Middle School, the restaurant has already an approved wet zone in place. According to the applicant, these are the justifications. The school building and student areas are outside the 500 feet radius. The school is on the south side of Elric Road, and this road is a 4-lane busy road which separates the school from the subject site. LDC Section 61111E3 provides for approval separation of waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impact to surrounding land uses, and certain circumstances negate the necessity for the specified distance requirements. Staff has evaluated the justification from the applicant and concurs with them regarding these waivers from these community uses. The proposed wet zone is within an established shopping center located along a commercial corridor. The existing wet zoning permits the sale, on-premises consumption of beer and liquor and wine in connection with a restaurant, as will the proposed wet zoning state, with the only difference being the allowance to serve alcohol in new and existing outdoor seating areas. Therefore, for these reasons discussed, the staff finds the proposed wet zoning does not pose significant impacts on surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances identified in this presentation and the staff report. Therefore, staff finds the request approvable, subject to recommended condition. The condition recommended is that upon approval of this special use permit 220063, the existing wet zoning of the premises under permit number 85-1216 shall be rescinded. Approval is based upon the survey indicated and submitted by the applicant, and the total area is 5,656.9 square feet. Of those, 4,242 square feet will be indoor space, and 1,414.1 square feet will be the proposed outdoor areas. And I'm available if you have any questions.
Thank you, Mr. Monsanto. All right. Is there anyone here or online who wishes to speak in support of this special use request? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this special use request? All right. Do not hear anyone. All right. Development Services, anything further?
No, ma'am.
All right. Thank you. Applicant, did you have anything further to add? No. Okay. Thank you. This will close the hearing then on special use AB 22-0063. And I believe we're still trying to make connection with variance 22-0161.
Popped up. Oh, I'm here. There you are.
Okay. Hold on for 1 second for me.
Yeah.
Can you hear me now? Mike, can you hear me? Mike, okay, so you have your phone on you, right?
Yeah.
What I'm gonna have you do is I'm gonna have you call in at this number. Write it down for me, all right?
Okay.
All right. You're gonna call in from this number at 408 418 9388. Now, what you're going to do is that you're going to use your video from your laptop and you're going to listen to us through your phone.
Okay.
All right. So call in through that number. It's going to ask you for the access code information, which is write this number down too as well.
Okay.
This is your access code. 2343 7335 4668.
Okay.
All right. Once you call in, that will ask you for the access code, and then you'll be able to hear us from your phone, okay?
Okay.
All right, so go through that process and give me a call back if you have any issues, all right?
What number would I call you? Okay.
The number that you're on right now with me.
Okay. All right. I'm going to do it right now.
Sounds good.
Thank you. Bye.
Yep.
Welcome to WebEx. Enter your access code or meeting number followed.
Hello.
Hello. Mike, can you hear us?
Yes, I can.
All right, excellent. Can you hear me now again?
Yes.
Mr. Kretzinger?
Yes, ma'am.
All right, this is Pamela Hatley. I'm the Land Use Hearing Officer.
How
right.
you doing today?
I'm fine. I need to swear you in, first of all, so please raise your hand to be sworn. All right, thank you. Do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. Please state your name and your address.
Michael Kretzinger, 17923 Barn Close Drive, Lutz, Florida, 33559.
Thank you, sir. All right. Can you explain, please, the variance that you're requesting and the hardship criteria, why you need the variance?
Yes, we have a 40-foot wide lot that we were trying to build a home on. And the original setbacks are 7.5 feet on the sides. We don't have a problem with the front and back. But we're only able to get a house.
Mike, can you
that
please
will
mute
work.
your phone?
Oh,
Just mute your phone on your end. So we're not getting 2 loops of feedback here.
Yeah, is that better? Or?
I think that's better. Please continue. I think it's better, yes.
Oh, okay. The house that we've designed that we'd like to put on there, we're going to need 5-foot setbacks rather than 7.5 foot setbacks in order to make it a livable residence for someone.
All right, and I guess what was the use of the lot before?
There was an existing home on there that I believe had that were within 5 foot, 6 foot of the sides of the house. It's since been removed.
Okay. All right, so that's all you want to do is build your residence there?
Yes.
All right, anything else you want to add?
I'm so nervous I can't stand it. How's that? I think that's it. I mean, it's right next to a marina that has acquired the property on one side. And then there's an existing residence to the opposite side that I believe it's the same owner that owns this property.
Okay. All right, thank you, Mr. Kretzinger. And just stand by. All right, is there anyone here or online who wishes to speak as a proponent in support of this variance request? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this variance request? Don't hear anyone. All right, Development Services, did you have anything further?
No, ma'am.
All right, thank you. And Mr. Kretzinger, did you have anything further you wish to add?
No, ma'am.
Okay, thank you. All right, that will close the hearing then on variance 22-0161. And that will conclude the Land Use Hearing Officer meeting for today.
Okay. Am I still here?
Thank you, Mike.